Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. My name is Matt Bisanz, and I am a partner in Mayor Brown's financial regulatory practice. I counsel domestic and foreign financial services firms on a variety of banking and derivative regulatory issues, and today I'm joined by my colleague Brad Resnikoff. He's also a partner in Mayor Brown's financial services regulatory and enforcement practice, and he counsels financial institutions on regulatory enforcement and various strategic matters of importance. Our topic today is one of those matters of importance, which is understanding FinCEN's new beneficial ownership information rule. We will discuss the recently published final rule and also some of the implications it will have for various sectors of the industry. But first, I'd like to step back briefly to a time long ago in 2001, back when Gladiator was on the screens and we were all listening to the latest Britney Spears CD. Among the legal implications was the Patriot Act, which was reshaping the field of anti-money laundering compliance. And one of the outgrowths of the Patriot Act was the greatly named SIP rule related to customer identification requirements, which was implemented in 2003 and required bank and similar financial institutions to perform customer identification and verification procedures to know the identity of their customers. But alas, the SIP rule had no look-through component, and so a legal entity customer was treated the same as you or me as a natural person customer. By 2016, that had begun to change, and FinCEN adopted the customer due diligence rule, which included a beneficial ownership component to look through and ensure that financial institutions collected certain beneficial owner information on their legal entity customers. However, this information stayed within the financial institutions, and so unless the government came calling or the financial institution encountered some type of suspicious activity that it felt compelled to report, the government wasn't privy to this beneficial ownership information. Accordingly, in late 2020, Congress addressed this concern by adopting the Anti-Money Laundering Act, which includes the Corporate Transparency Act. And Brad, I think that's probably where you will come in to start with the meat of our presentation.
Thank you, Matt. And before we get into the nitty-gritty of the rule, I wanted to just make a few general remarks about its coverage, touch on a little bit more about its origin and also its purpose. I think that the most important point here is that the rule is very broad in scope. It's going to apply to a very large number of legal entities. It's going to have an effect on a large number of industries and markets. It's going to require the reporting of personal identifying information belonging to a large number of senior individuals working for reporting companies, as well as potentially junior persons who perform mostly administrative functions like filing the paperwork for the registration of a legal entity. I think it's also worth mentioning that this rule is part of a broader effort of the Biden administration to curb corruption and increase transparency. The rule implements the most significant provision of the Corporate Transparency Act, and it has been a long time in the making. For decades, states' attorneys general successfully thwarted this type of federal regulation, or legislation rather, and various iterations of beneficial ownership registries have fallen to the wayside over the years. As Matt mentioned, this final rule was issued very recently by FinCEN, just about 2 weeks ago now, after 2 rounds of notice and comment rulemaking. For those of you who have been tracking the rule, the final rule largely follows the December 2021 proposal, but it does also incorporate some modifications to address industry concerns and otherwise clarify certain provisions. And so we're going to highlight some of these differences as we go through. The purpose of the rule is to create a centralized, comprehensive database of beneficial ownership information to assist law enforcement in its efforts to impede bad actors from abusing legal entities, like shell companies, to conceal proceeds of corrupt and criminal acts. The regulation aligns the US with the UK and member states of the European Union, which have already incorporated certain beneficial owner reporting elements into their domestic legal or regulatory frameworks. One major difference, however, is that unlike in the UK and the EU, access to the US registry will be limited to certain authorized parties. It will not be made public. So with that background, let's talk a little bit about what this rule requires. It requires reporting companies to register with FinCEN and disclose to FinCEN the identity of individual beneficial owners and company applicants. The definition of reporting company is sweepingly broad. It includes most US entities, including corporations, LLCs, and other entities registered to do business with the Secretary of State or similar office, as well as non-US entities registered to do business in the United States. FinCEN has said that the broad definition of reporting company is meant to capture limited liability partnerships, limited liability limited partnerships, business trusts, and most limited partnerships, subject to specific exemptions, which we'll discuss in just a moment. A database containing beneficial ownership information will be maintained by FinCEN and made available to law enforcement. U.S. financial institutions may access information in the database reported by their legal entity customers who authorize such access. Willful failure to register and disclose beneficial ownership information carries both civil and criminal penalties, which aligns with the purpose of the rule, which is it's for law enforcement and it's meant to thwart criminal activity. So there are 23 types of entities exempted from the registration and disclosure requirements of the rule. The devil's in the details, as you might expect. Some of them are straightforward, and some are a little bit more difficult to parse through. So I'm going to turn it over now to Matt to highlight some of the more significant exemptions.
Sure, Brad. Thank you. And you're right that some make a lot of sense, like the exemption for U.S. banks, that someone who's going to be committing bad acts would find much easier to do it through something other than a U.S. bank, because the U.S. bank regulators are constantly in banks and checking who owns them and how they're using them. So that one was a gimme. Another one that is pretty obvious is U.S. public companies, that if you're going to the trouble to do a public securities offering, if you're filing the detail required of an S1 and hiring outside counsel to do that, again, not the type of thing that your typical money launderer is going to do when there are other options available. Some of the exempt entities, though, there are some wrinkles to it. And so there is an exemption for insurance companies. And for this purpose, they use the definition of insurance company from the Investment Company Act. And I think we probably all are familiar with insurance companies in the sense that I have a company that gives me homeowners insurance, and I have a company that gives me auto insurance. There's actually a diversity of insurance companies out there who provide very sophisticated services. There are captive insurance companies that might be owned by one or a small number of insured organizations. There's foreign insurance companies and reinsurance companies, all of whom can do business in the U.S. under certain circumstances, and may or may not, depending again on the particular structure and the amount of interpretive gloss provided by the SEC, meet the definition of an insurance company under the Investment Company Act. And so I think that's one example of an exemption that on its face sounds pretty straightforward, but in practice will probably raise a lot of questions from regulated entities and similar market participants about whether or not they qualify for the exemption. But most of us on the call are not worried that we might be insurance companies, or maybe that we don't qualify as an insurance company under an 80-year-old securities law. We're probably looking at some of the more practical exemptions. And there's an exemption out there for large non-public operating companies. And a large operating company for these purposes is an entity that has more than 20 full-time employees in the United States, and that's counting full-time employees as they are counted for federal tax purposes. It also has to have an operating presence at a physical office in the US. So storefront is fine, PO box, not fine. Um, and it needs to have filed a federal tax return in the prior year that shows more than 5 million in gross receipts or sales. Now, for companies that are part of a consolidated group, it's fine if they use the consolidated group's return or their own return, but it does need to be a US tax return, information or income tax return. Another exemption that we think will be available to a lot of companies is the exemption for subsidiaries of many types of exempt entities. And so if you are looking at the pyramid of a public company, obviously the public company at the top of the pyramid is probably going to be the only legal entity that is an SEC reporter. That if you go down into some nuanced securitization vehicle or some warehouse owning LLC further down, those subsidiaries, they aren't public companies. They're owned by a public company, but they aren't a public company. And so the rule includes an exemption for subsidiaries of certain types of exempt entities. The caveat to this that we've already started encountering with some people is that the subsidiary must be wholly owned by the qualifying exempt entities. And so if you were to have, say, a joint venture with a highly compensated employee that maybe I'll use Brad because he's on the call with me here as an example, that Brad was compensated by getting a 10% share in this subsidiary. He gets a 10% profit share, and the other 90% is owned by a public company. That subsidiary is no longer going to be exempt because Brad is not an exempt entity, that it needs to be a wholly owned by the exempt entities, in this case, wholly owned by the public company. There might be 3 or 4 public companies going in on a joint venture. That's fine. But being a wholly owned subsidiary is a requirement, and we think it's going to be something that a lot of people are going to have to confront when they look at some of the definition of ownership interest in the beneficial ownership rule, which is quite broad. And lastly, for many of Mayor Brown's clients, there are multiple exemptions that address pooled investment vehicles or other types of collective investment vehicles. There's one for registered investment companies, which again is pretty straightforward. There's other ones for commodity pool operators and similar CFTC regulated entities. And then there's one for U.S. pooled investment vehicles that are operated or advised by certain types of exempt entities, such as if someone's a pooled investment vehicle that is advised by an SEC registered investment advisor. The wrinkle here, and this is a narrowing of the exemption that is in the CDD rule, is that to qualify for the exemption under the new BOI rule, the vehicle must be a 3C1 or 3C7 fund under the Investment Company Act, so a hedge fund or a private equity fund in most cases, and it must be identified by its legal name on the relevant investment advisor's Form ADV. So not only do you have to be relying on the 3C1 or 3C7 exception in the Investment Company Act, but you also have to be named in the investment advisor's Form ADV. And so that is a welcome exemption, of course, but it is significantly narrower than the analog in the CDD rule. The BOI rule also distinguishes between U.S. pooled investment vehicles and foreign pooled investment vehicles. While a U.S. pooled investment vehicle that meets the criteria I just defined gets a full exemption, doesn't have to file anything with FinCEN, a foreign pooled investment vehicle that meets the same criteria has to file some limited information with FinCEN regarding its beneficial owners. And so it has a limited or a partial exemption from the BFI rule. With that, I think I'll turn things back over to Brad.
Thank you, Matt. I think it's also worth noting that FinCEN is not precluded from adding exemptions in the future, including after the final rules effective date. FinCEN has noted that it will continue to consider whether new exemptions would be appropriate if prompted to do so. So if you think you're a current non-exempt entity and you're, let's say, regulated by other government agencies or foreign governments, and compliance with the rule appears to you to be duplicative of existing regulations or overly burdensome, we suggest you consider engagement with FinCEN. It's not too late. Let's switch gears now and talk a little bit about the definitions of beneficial owners and company applicants, the individuals who are going to be subject to disclosure under the rule. A beneficial owner is defined as individuals who exercise substantial control over the entity, or those who own or control not less than 25% of the ownership interests of the entity. Now, FinCEN in its final rule has clarified what it means to exercise substantial control over a reporting company. There's three indicia that FinCEN points to. One is service as a senior officer. Second is authority over the appointment or removal of any a senior officer or a majority of the board of directors or similar body. And third is one who directs, determines, or has substantial influence over important decisions of the company, including decisions regarding the nature, scope, and attributes of the business, reorganization, merger, dissolution, major expenditures or investments, and various other things that are spelled out in FinCEN's preamble. As a consequence, reporting companies will be required to identify a potentially large number of senior executives, among others, as beneficial owners under the rule, even if such persons have no ownership interest, no sort of classic financial interest in the company. We also think this might be particularly burdensome for foreign companies, subject to comprehensive privacy laws, such as GDPR, which could be required to disclose the foreign residential addresses of executives, for example. Turning to the definition of ownership interests, the rule defines what it means to own or control not less than 25% of the ownership interests of the entity by defining ownership interests, which may be held through trusts or similar arrangements, providing guidance on how to calculate a 25% ownership interest, which generally speaking is done by aggregating all of the individual's ownership interests in comparison to the undiluted ownership interests of the company, and explaining how an individual can own or control interests, which can be done directly or indirectly. Notably, ownership interests include all instruments that represent a capital interest in the reporting company, or a right or interest in the value of the reporting company or its profits. This, we think, could include equity kickers and potentially other instruments with equity-like attributes, such as preferred shares. The final rule also specifies the types of relationships through which ownership or control of ownership interests may occur, such as through another individual acting as a nominee, intermediary, custodian, or agent. And last, the final rule also makes clear that an individual may own or control a reporting company through his or her ownership or control of intermediary entities. Turning to the definition of company applicants and continuing the theme here, the definition is also quite broad. For domestic reporting companies, the rule defines a company applicant as an individual who files the document that forms the entity. For foreign reporting companies, a company applicant is the individual who files the document that first registers the entity to do business in the United States. In both cases, anyone who directs or controls the person who files the relevant document would also be a company applicant. So this can apply to more than one individual. It's also worth noting with respect to this definition that in a departure from FinCEN's proposal, the final rule makes a distinction between existing and newly formed companies. So if a company was formed prior to the effective date of the rule, then it has no requirement to report company applicants. This means that unlike in the proposed rule, long-established reporting companies would not be required to obtain information for any company applicant going, potentially back decades and decades. So briefly, let's just talk about what information has to be reported about reporting companies and beneficial owners and company applicants. So covered corporate entities must report their own name, including any alternative names, address, jurisdiction of formation, and for each beneficial owner and company applicant, their name, birthday, address, and a copy of an identification document. Turning now to the timing of this of the effective date of the rule, it's January 1st, 2024 is the effective date of the rule. For domestic and foreign reporting companies formed or registered after the final regulation, the reporting company must file with FinCEN 30 calendar days after formation or registration. This is a welcome change from the rule proposal, which allotted only 14 days for the filing. Entities formed or registered before the effective date of the final rule are required to file a report no later than 1 year after the effective date of the regulation, or January 1, 2025. According to FinCEN's acting director, FinCEN has been developing the backbone, the IT infrastructure of the beneficial ownership database. FinCEN has gathered its initial requirements and is completing system engineering, architecture, program planning, and the like, and the initial build of the cloud infrastructure are in progress. But I think the plumbing is going to take a little bit of time here, right? I mean, data security. We're dealing with personal identification information, and so data security is of the utmost importance. And I think, as Matt mentioned at the top, the CDD rule does still remain in effect, and so banks will continue to require the provision of beneficial ownership information from entities even after this new rule goes into effect in January 2024. So, what's next? I think although the rule implementing the registration and reporting requirements has been finalized, there's still quite a bit of work for FinCEN to do here. There's further rulemakings planned, including one that will define the contours of access to the database, and another intended to harmonize the CDD rule with the standards adopted in this new regulation. You heard Matt talk about, in the context of exemptions, some of the differences where this new rule is actually a bit more narrow. And so the expectation is that FinCEN is going to align the CDD rule with this new BOI rule. It also remains to be seen whether and how information reported by legal entities will be verified. Neither the statute nor FinCEN's proposed rules include a verification mechanism. And so there's concern on the part of the financial services industry that the banks will wind up being the responsible party. Industry groups have expressed this concern to the government. This is a government database primarily for use by law enforcement, and therefore it should be up to the government to verify the information reported. But FinCEN is somewhat under-resourced, and we're not sure it has the ability to perform such a function as currently constituted. So this is an important issue. We have an effective date, but this is an important issue that deserves further discussion before the database is operationalized. So what can you do to prepare for compliance with this rule? I mean, I think the first step is just sort of socializing it within your organization. I think AML compliance obligations are foreign to a lot of the entities and industries and markets to which this new rule is going to apply. Banks have been doing this for a long time, but not everybody else. And so I think most are going to have to devote additional compliance resources to making sure your organization is in compliance with this rule. And we don't think it's too early to start. Soon enough it'll be year end, and then this rule is going to be 1 year away from the effective date. From a substantive perspective, we would suggest you first determine whether any exemptions can apply. FinCEN is not going to award a certificate of exemption for you to hang on the fridge. This is a determination that must be made by each organization, and it must be made on an entity by entity basis. If an exemption does not apply, and you've reached out to FinCEN and it's not likely that they're going to consider another exemption that would fit your circumstance, beginning to sketch a compliance process out seems like the logical next step to us. To the extent you're facing unique or complex issues, obviously we're happy to help you work through the complexities of this rule.
Brad, thank you so much, and thanks to our audience for listening. Listeners, if you have any questions about today's podcast or anything else related to global financial markets, please feel free to email us at gfm@mayorbrown.com. That's the email address that this notice came from, or also reach out to Brad or myself. We're both easily found on the internet. It's been a pleasure speaking with you today, and thanks for listening.
Thank you.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.